Okay, good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin, LLP in Toronto. It's great to be back with you. I do many of these live Q&A sessions, so I'm happy to answer your questions live again today. All the important employment law related topics, please feel free to answer your questions. As you know, we do multiple of these sessions every single week across our offices. We have offices in Ontario, in Alberta, and in British Columbia. And the goal, as you know, is to get as many questions answered live and to ensure that the public understands their employment law rights. So that's what I'm here to do today. As I usually do, I'm going to start off with an important topic, a hot topic that's going on in the world of employment law. And what we're going to talk about today is the company Loblaw, and it's a famous company. They're co-owned alongside Shoppers Drug Mart, and they're planning to create a major investment, and in turn, that will create approximately 7,500 jobs in Canada. And this intends to be in 2024. Now, what's very important is it's great when there are jobs created, the economy is doing well, the labor economy. But what's very important is for everyone to understand that when you get a new job, often, not always, but you're asked to sign an employment contract or an employment agreement. Very, very critical that if you're asked to sign such an agreement, that you have that reviewed by a member of my team at Samfiru Tumarkin. The employment contract is very important. It sets out the terms of your employment, the conditions of your employment, and there are many important terms. One of the most important areas in such a contract is the area about terminations and what your entitlements are if you are ever terminated from that company. And so it's very important for you to understand that. Sometimes, in fact, often, the termination provisions in an employment contract try to limit your entitlements to severance to the minimum amounts. Okay, there's minimum amounts, and then there's severance pay that is up to 24 months of pay, which is very significant. And you want to ensure that you can get those maximum severance entitlements. Many employment contracts try to limit that, and they can do so legally. And therefore, it's critical that you have an employment lawyer from our team review the contract before you sign it, because that is the point in time where the terms are negotiable. You can negotiate the termination sections or any other section of the employment contract. But after you sign the agreement, it's usually a binding enforceable agreement, and therefore you can't really negotiate at that point forward. So very, very important, have those terms reviewed. And so for all of those new jobs that are going to be created in Loblaw, very important that they have their employment contracts reviewed as well. Okay, so with that, we will jump to the live questions. We have a question live on YouTube from Esprit. I was recently asked to choose between a PIP. A PIP is a performance improvement plan, for everybody to understand that. So I was recently asked to choose between a PIP for low performance and demotion. The facts in the PIP are not right, and I do not want to take a demotion. Can I be terminated for disagreeing with either option? Should I sign the PIP? Will I be eligible for severance? I'm with this company for 4 years at a mid-management position. Okay. So excellent question. Very common situation where an employer might have some concerns with an employee's performance, and they want that employee to sign what's called a PIP, a performance improvement plan, that usually will dictate the issues that the employer has with that employee's performance and the ways in which the employer expects the employee to improve their performance. And it usually sets out certain targets of when the performance has to be improved, by when and how much. some of these targets are not fair. Some of the dates are not fair. So important to note that if you don't agree with what is stated in the PIP, you have to make that clear. If you sign it, it indicates that you are agreeing with what is stated in that PIP. If you have comments that you want to make, perhaps you don't agree with certain things that are stated, which is very common, but you might agree with other things. Well, you got to make that very clear to your employer, and the PIP should reflect ultimately the back and forth that you've had with your employer about the performance and the performance issues potentially. Okay, so after you've raised your concerns with it, the PIP should be revised accordingly. And if you are terminated for not signing the PIP, you would be entitled to your severance pay 100%. And as we talked about, your severance can be as much as 24 months of pay. So you definitely should not just assume that if the employer has performance concerns with you and they want you to sign a PIP and you don't sign it, that you just don't get your severance pay. Okay. You absolutely would be entitled to severance. And for a 4-year position, I mean, it depends if you're mid-management, depends on what you're earning, what your age is, but you could be entitled to anywhere between 4 and 8 months of pay, potentially even more. It depends on other factors. So certainly you should understand that severance does not go away just because you won't agree to sign a PIP. Okay, let us move on. I hope that answers that question. And if anyone has a follow-up, feel free to post it in the chat, of course. We have another question on Facebook from Bree. I'm unable to do the on-call work my employer is implementing. It is for medical reasons, and I have provided a doctor's note. Can my employer let me go because of this? Your employer might let you go, but it would be certainly problematic. One, you would be entitled to your severance pay. If your employer lets you go, then you're entitled to severance, okay? If your employer lets you go because you have explained that you have a certain medical reason why you can't do an element of your job, including on-call work, and you have provided documentation, medical documentation, to support the fact that you cannot do this part of your job, your employer, if they let you go, not only are you entitled to severance pay, but you could easily potentially be entitled to human rights damages as well, because that is potentially a breach of the Human Rights Code, right? The Human Rights Code does not permit an employer to terminate you for reasons related to your medical status or potential disability. If your employer does do that, then there are serious implications, and your employer is going to be liable for that. So I hope that answers that question clearly. If there is a breach of your human rights, according to our legislation, the Human Rights Code, then yes, that is a significant element over and above the severance that you would be entitled to just because you were terminated. Okay, so Bree, I hope that answers that question. And if you have a follow-up, or if anyone has a follow-up, feel free to post it in the chat. Okay, we have a question on YouTube from Christian. I just want to know if you take on labor cases of wrongful dismissal from worker-related accidents due to unsafe working conditions and discrimination, even after 2 years. Okay, so let's talk about the last part of your question for a minute. Usually, if what you mean by 2 years is the incident or the termination happened more than 2 years ago, then you might run into a problem from a legal standpoint, because you usually have 2 years to pursue your rights, your legal rights. That's called a limitation period. But let us investigate this. There might be ways around that, and certainly these are kinds of cases that we do take on. We are very experienced in dealing with. So Christian, I definitely recommend that you call us and you arrange a consultation, and we can chat about the issues and we can learn more about the case. And then we'll be able to fully advise you on what your entitlements might be. Okay, so please contact us. You can do so at help@employmentlawyer.ca. Also, at this point in time, it's important for me to note that we have tons of resources and further information on all the topics we discuss. And you can find all of that at employmentlawyer.ca. We have a wealth of information there, and it's all free and anonymous and easy to find on our website. So please make sure that you take a look at that. And you'll learn a lot about your employment rights. If you have further thoughts or questions, and I haven't been able to answer that during this session, definitely take a look at employmentlawyer.ca. Another thing to note is that we spend a lot of time, of course, talking about severance and the amount of severance a person might be entitled to when they are terminated from their job. So the way severance is determined is by looking at various factors. And those factors are the employee's age, length of service, position, level of remuneration or compensation. And those factors are assessed, and then we are able to determine how much severance you're entitled to. As you see right here on the screen, we have a tool called the Pocket Employment Lawyer. Pocket Employment Lawyer is a tool that we've created that has all sorts of information related to employment law and employment-related questions. And in that, we have what's called a severance pay calculator. So if you go to pocketemploymentlawyer.ca, you will find our severance pay calculator. And that severance pay calculator is a free and anonymous tool that allows you to input certain information about your job and about you. It will ask you your age. It will ask you how long you've worked for the company. It will ask what position you're in, how much money you're earning. And then right away, the severance pay calculator will be able to quantify how much severance you would be entitled to. Okay, so it's a very, very easy to use tool. Like I said, it's free and anonymous. I definitely encourage everyone who's listening to check out that tool. Again, pocketemploymentlawyer.ca. And you can use it if you've been terminated, or even if you haven't been terminated yet, if you expect you might be terminated, and even if you don't expect you might be terminated. Check it out, and you'll get a sense of the kind of severance that you're entitled to, and then ensure that you contact us, and we will help you get that severance pay. Okay. As we wait for additional questions, another very important topic that I want to raise is the idea of a mass termination. And we're seeing this across tech companies. We've been seeing it for quite a while now. We just heard an announcement that Nike is laying off more than 1,500 workers, many of whom might be in Canada. It's unclear exactly how many Canadian employees will be terminated. But if they are terminated, they are going to be provided with termination agreements. Okay. And we deal with these kinds of agreements all the time when an employer is terminating many people at once. And usually those types of termination agreements are what I always call a one-size-fits-all termination contract. Usually it's a certain severance package that forms part of that termination agreement. And the severance pay is going to look very similar across all of the employees who were terminated. It shouldn't, but it often does. So it will say to everybody, you're going to get X amount of severance. And the company doesn't take into consideration that employee's particular circumstances. Each employee's circumstances are, of course, different. One is a certain age versus another employee. They might have different jobs. They might have worked for the company for different amounts of time. All of those, as I've explained already, are the key factors for determining how much severance an employee would be entitled to. So a company cannot just say we're laying off thousands of workers and you're all getting identical or very similar severance packages. They should look different because it does depend on the employee's particular circumstances. So if you are terminated from a company, and even if you think, well, the company's suffering financially, they don't have the income, they don't have the revenue or the profit to pay us a reasonable severance package, you're wrong about that. The employer is obligated to pay you your severance based on your entitlements. Even if the employer is not doing well financially, that could be the very reason why they terminated you or laid you off. Doesn't change the fact that you are entitled to your severance pay. Okay? And again, it can't be a one size fits all. It has to be based on your particular circumstances. All right? And just to note as well, if you are laid off, so if you are told by your employer that you're going to be temporarily laid off, so different from a termination, a layoff, a temporary layoff, is where the company is telling you that we're not terminating your employment, but we're just laying you off for a certain amount of time. And sometimes the company will say, we expect to recall you back to work on a certain date, or they might say in a matter of a certain amount of weeks. If that happens, you can also treat that as a termination. So even though the employer is representing it as just a temporary layoff and they expect to call you back, that's not necessarily true. It is a termination if you treat it as a termination. And that's what we call a constructive dismissal. Okay? It is a situation where the employer is changing significantly terms of your employment that you don't agree with. In this case, they're laying you off. If you didn't agree to be laid off temporarily, you can treat that layoff as a termination, and you would be entitled to your full severance, just as if you were terminated on a without cause basis. And another thing to note that's important is if you sign an employment contract, and the employment contract says that the employer is permitted to lay you off, then in that case, if the contract was drafted properly, they would be permitted to lay you off, and it would be legal, and you would not be able to treat it as a termination. So very, very important. Again, as we talked about earlier during this session, you have to have your employment contracts reviewed. You have to make sure that there aren't provisions in there that allow the employer to significantly change terms of your employment. Because if you do permit your employer to do that, if it forms part of the contract, you can't come along later and say, well, I don't agree. I don't agree to being temporarily laid off. Another example of a constructive dismissal, again, another type of situation where your employer is significantly changing key terms of your employment, would be if your employer reduces your pay. You could earn $100,000 a year, and the employer comes along and says, things are tough for us. We're going to dock your pay to $80,000 a year, for example. In that situation, that pay cut is a constructive dismissal. It's not your employer telling you straight up or outright that you are being terminated. Okay? But what they're doing is significantly changing a key term of your employment, and that is your pay. Of course, that's a key term of your employment, how much you're paid. And if you're paid a certain amount and your employer just changes that unilaterally without your consent, you can treat that as a termination of your employment. Again, though, it depends on what your contract says. If the contract permits the employer to implement these significant changes to your employment, then you cannot treat that as a termination. Okay? Let us move on. We have some more questions that have come in, so I want to address those. We have a question from S on YouTube. What entitles you to severance? Should a person be on contract to receive severance? Good question. No, you don't have to have signed an employment contract in order to receive severance pay. If you are working as an employee for an employer, then you are entitled to severance pay. Now, I do want to qualify one thing I've said. I said if you're working as an employee. If you are designated as something other than an employee, some sort of contractor or consultant, you might still be entitled to your severance pay because you might actually be an employee according to the law. So even if you might have signed a contract that says, I agree to be an independent contractor or a consultant for a certain company. It might be that you are actually an employee. If you operate like an employee, the law would say you are an employee, and therefore, if you're let go from that position, you're going to be entitled to your severance pay. Okay, even if that contract very explicitly says that you're not an employee, the law looks at the actual relationship between you and your employer. Okay, did you work elsewhere? Did you work around 40 hours a week? How were you paid? All sorts of things. Did you have an office? Did you have a work email address? Who provided you the tools to do your job? Were you given a laptop? Were you given pens, paper, printer, etc.? All of these things are considered in assessing whether you are an employee or a contractor. So for those people who are unsure what your status is, please contact us. We'll arrange a consultation. We'll advise you as to your status. And again, if we believe that you are an employee, you will be entitled to severance pay, and we can pursue that for you. Okay, so S, I hope that answers the question. And if you have a follow-up, please post it in the chat. Okay, we have a question from GBRVDA on YouTube. Employer sold parts of the business, including my product. New job offer went from 100% salary to 50% of my former salary, and the rest is commission. Do I have to take it? No, you don't. If that seems to be a significant change, right? We're paid before 100% salary, and now 50% of that is your salary, and the rest is commission. And I imagine the commission is not guaranteed. You may not get those earnings, so that is a significant change to the way you're paid. So you don't have to accept that, and you can treat that as a termination of your employment. This is a great situation, a great example, rather, of constructive dismissal. So please, you can contact us, arrange a consultation, and we'll advise you further, and we'll talk about what next steps look like for you. Your severance entitlements are potentially very significant, given your 22 years tenure and your age. Okay, S has a follow-up. What if you know it's a permanent layoff and the job wasn't completed? So even if it's a permanent layoff and not a temporary layoff, you're still entitled to your severance pay, right? If it's a permanent layoff, if it's expressed as a permanent layoff, that's a termination. So you're entitled to your severance. And even if it's expressed as a temporary layoff, but you have reason to believe that it isn't a temporary layoff, doesn't change the fact that you're going to be entitled to obtain your severance pay. Okay? Lots of good questions here. Let's move on. We have one on YouTube from DN. Is my employer obligated to return my office to me once I return from disability leave? Good question. So if you're on disability leave, you come back to work and you worked in a certain office and now you don't have it anymore. So I would say it depends on why you don't have that office anymore. If the employer, got a new space, a new floor on a certain building, or they just changed office space completely, and therefore you and other people who had offices don't have offices anymore, arguably that might be a constructive dismissal, but you're going to have a difficult time proving that. If you're the only person or one of the only people who are singled out and you come back from your disability leave, nothing about the overall office space has changed, but you don't have your particular office anymore, then yes, you might be able to say, well, that's a significant change to the terms of my employment. It also depends on why. It depends on why the employer has gotten rid of your office. Okay? So again, another good question. I answered it, and hopefully DN now has the information that they need. And if DN wants to arrange a consultation, please do so, and we can talk more about this. Okay. So we have a question from Frank on YouTube. Can my employer freeze my RRSP, the contributions made, till our court case regarding severance is settled? I wouldn't want to advise you on this. If you have an ongoing legal dispute, Frank, you should speak with your lawyer about that if you have a lawyer, and they could advise you on whether your RSP contributions and the company's contributions should be paid out to you. So please do that, Frank. Okay, we have another question on Facebook from Val. I'm currently on a sick leave. My employer sent me a letter that due to business decline, they've completed a restricting and a restructuring, perhaps you mean, and my position has been eliminated. They offered me a new position, similar to what I was doing before. But if I reject the offer, is that considered a resignation, or can I file for constructive dismissal? Good question. So if there really was a restructuring and your position was eliminated, because sometimes employers will use that as a generic reason and it hasn't really occurred. But let's just assume for a minute that it has occurred and there really was that restructuring that occurred. Then if you're offered a new position, if you don't take it, if that position is more or less similar in terms of your pay, your duties, the other elements of your employment, where you work, how you work, who you report to, etc. If most of those things are the same, then you're going to have a difficult time arguing that there's a constructive dismissal there, because even though there might be some changes, there have to be significant changes to the terms of your employment. If there aren't significant changes to the terms of your employment, Val, then it makes it more difficult to prove that you were constructively dismissed. So you, of course, don't have to take the new job when you return from sick leave. But you might be right that it is considered a resignation if you don't take it. But I need to know more details about the particular changes to the position and how the new position relates to your current position. And perhaps there really are some significant changes there. And if that's the case, then no, you don't have to accept that new position. You can argue that you've been constructively dismissed and you can obtain your full severance pay in that case. Okay, so Val, it makes sense that you arrange a consultation with me so that we can really particularize what changes have occurred with this new position, and then I can advise you further on that. Okay, we have a question on YouTube from Lex. Excellent questions today. We're getting many of them. I'm very pleased to see that on all different types of information here. So, Lex, if I sue my ex-employer for damages and severance and lose, will I be ordered to pay my employer's legal fees? Yes, you might potentially be ordered to pay some of those legal fees. If you pursue a case and you lose the case, it gets all the way to a hearing or a trial, and you lose and your employer has costs, then you might be responsible to pay for some of those costs. It really depends, though. I know you say you're in BC. The laws in Ontario might vary a little bit in terms of the amount of costs you'd have to pay. But yes, that is a potential reality. But again, that assumes that you are commencing a legal action and that you lose and that the case went all the way to a final hearing or a trial. That usually does not happen. Usually cases settle pretty quickly and that doesn't happen. So I wouldn't worry too much about it. Okay, we will leave it there. We have another session tomorrow, I believe, with my colleague Dan at 1:30 p.m. Friday, February 23rd. So tune in for that session. Dan will be here to answer more questions for you. And it was great being with you. Thank you very much. Take care, and I look forward to joining you again soon.